What is mediation and why do I need it? Mediation involves each side with their lawyer meeting with a neutral lawyer. And that neutral lawyer is there to try to mediate the case, to try to identify the issues and try to get everybody to compromise on what their positions are. Each side can have the peace of mind knowing that they've reached a settlement that they have personally agreed to. Mediators are not there to determine who is right and who is wrong. They're only there to try to find some common ground and then find out what each side wants and what's important to them in trying to give each side a little bit of what they want. It's not like a trial. It's not binding. At a trial, a judge would hear all the facts and hear all the testimony and the evidence, review documentation, and then make a decision on what should happen based on what the law is. Each side will prepare what's called a mediation summary. Each side will identify what the issues are in the case. That summary will outline the facts that are relevant to the decisions that they want made in their favor, and it will identify the issues and what they believe should happen on all those issues, such as custody, parenting time, what should happen with a house, what should happen with retirement, what should happen with child support, what should happen with spousal support, and any other issues that may exist in a divorce case. You're not providing all the documentation in your case. You're not providing witnesses for the case. They will not be present at a mediation. The mediator will have reviewed both of those summaries. The mediator will be familiar with what all the issues are. And based on those summaries, the mediator will typically have a pretty good idea of what is important to one side or the other. What typically happens is each side is in a separate conference room, or if the mediation is being held by Zoom, each side will be in their own separate breakout room. Then the mediator will start by talking with one side and then go to the other, and we'll keep going back and forth and listen to what their argument is and listen to their opinions are as to what that other position is. They often call it shuttle diplomacy in going back and forth. That mediator does not share the conversations that each client and their attorney have with them, but it does allow each client and the attorney to be very candid with the mediator to say, this is what is important to me, or this is what I will not budge on. This is a non-starter. This is something that if we don't get this, then we are not going to resolve this case. So the mediator will go back and forth in trying to get the case resolved. The mediator is not there to say that one side or the other is right or that one side or the other is wrong. You can be aggressive in a mediation, but you have to be very careful because the goal is to try to get a case resolved. Why do you want to get a case resolved at mediation? The primary reason is that you don't want to spend the time, you don't want to spend the money, and you don't want to have the emotional and psychological impact on what a trial would impose on somebody. It could easily go into the tens of thousands of dollars. If you have a lot of issues, it can be a very difficult process for both sides, especially when you're dealing with children. It's very difficult because you're never really sure what's going to happen. At a mediation, it is non-binding. Nobody can force anybody to reach a settlement in a mediation. If you go to trial, that's going to be binding. Whatever the judge says is going to be the final say-so, and all you can do is appeal from that. At a mediation, it's not binding, but you have the opportunity to try to get a little bit more of what you want in one area of the divorce in exchange for perhaps a little bit less of something. You have the opportunity to control your destiny when you're in a mediation, and that's one of the advantages. Almost every judge in the state of Michigan is going to require that you go to mediation if you can't get the case resolved on your own. At a mediation, each side is going to have to present the information, at least some of the information that they have, and identify the issues that are important to them. And when you expose those issues to the light of day and to review by a neutral lawyer, sometimes it gives the opportunity to really reflect on what is or isn't important, to reflect on how strong their case may really be in a certain area. A lot of times in divorce cases, people hold the cards close to their chest. They don't want the other side to know what they're thinking. They don't want the other side to know what information that they have. There's supposed to be an open and free information exchange between each side, and hopefully before mediation, all the information that may exist in a particular case will be shared so everybody knows the same information. The question is, what do you do with that information? What does the law allow? What does the law require in a certain case? A neutral lawyer has the opportunity in a closed room, whether it be in a conference room or in a Zoom room, it has the opportunity to say, I just don't think you're right. Or I know this judge and I know how this judge thinks. I know how the courts process this information. So you may want to seriously consider that this detail could go for you, or this detail or this fact or this issue could go against you. It's that opportunity to have that discussion in a little bit more clarity than you might otherwise have if it's just you and your lawyer sitting in your office knowing that you're right, and the other side is sitting in their office having a conversation with their client knowing that they are right. But when you open it up into a mediation and you present that information, it allows to have an open discussion. Even though it's happening separately, the mediator, that neutral lawyer, can test the waters as to what kind of settlement may or may not be available. There's many benefits to mediation, especially as long as you have all the information that you need. You can find out what the other side is thinking. You can find out what their position is. You can consider and reconsider your own position on certain facts and certain details, and then make the decision on what is important to you. There are times when the other side is not going to agree, and you have no choice but to go to trial. It is important to know that a mediator does not make any decisions. It is non-binding. Each side has to reach an agreement and has to reach a settlement on all the issues before a mediation is successful in getting a case resolved. That mediator does not share any information with the court. They don't make a written recommendation to the court saying, well, this is what I see, and this is what I think should have happened, and this side was being unreasonable, or that side was asking for too much. All they do is report to the court whether there was a settlement or there was not a settlement. That whole process lends itself to each side presenting their case to find a compromise, to try to get a case resolved, so that each side can have the peace of mind knowing that they've reached a settlement that they have personally agreed to with the assistance of their attorney, hopefully understanding the law and how it applies to their facts, and making smart decisions about whether they want to spend the time and the money moving forward to a trial that can be very destructive, particularly when there are children involved.